Start. In view of the fact that the respondents continued on a higher post under the orders of this court for years together, and even after dismissal of the petition filed by the state, and the exercise for making promotions was not undertaken by the state authorities, the appellants should not suffer for no fault of theirs. It has fairly been conceded by the learned counsel appearing for the respondents that had the exercise of making promotions been undertaken immediately after the order of this court dated 19/8/1998, the appellants could have been promoted much earlier and they could have been senior to the respondents. Thus, the question does arise as to whether the appellants should be asked to suffer for the interim order passed by this court in a case having no merits at all. No litigant can derive any benefit from mere pendency of case in a court of law, as the interim order always merges in the final order to be passed in the case, and if the writ petition is ultimately dismissed, then interim order stands nullified automatically. A party cannot be allowed to take any benefit of its own wrongs by getting an interim order and thereafter blame the court. The fact that the writ is found ultimately devoid of any merit shows that a frivolous writ petition had been filed. The maxim, which means that the act of the court shall prejudice no one, becomes applicable in such a case, in such a fact situation. The court is under an obligation to undo the wrong done to a party by the act of the court. Thus, any undeserved or unfair advantage gained by a party invoking the jurisdiction of the court must be neutralized, as the institution of litigation cannot be permitted to confer any advantage on a suitor from delayed action by the act of the court. In Ram Krishna Verma vs. State of UP 1992, 2 SCC 620 AIR 1992 SC 1888, this court examined the similar issue while placing reliance upon its earlier judgment and held that no person can suffer from the act of the court, and in case an interim order has been passed and the petitioner takes advantage thereof and ultimately the petition is found to be without any merit and is dismissed, the interest of justice requires that any undeserved or unfair advantage gained by a party invoking the jurisdiction of the court must be neutralized. This court observed that while granting the interim relief, the court in exercise of its discretionary power should also adopt the procedure of calling upon the plaintiff to file a bond to the satisfaction of the court, that in the event of his failing in the suit to obtain the relief asked for in the plaint, he would adequately compensate the defendant for the loss ensured due to the order of injunction granted in favor of the plaintiff. Even otherwise, the court, while exercising its equity jurisdiction in granting injunction, is also competent to grant adequate compensation to mitigate the damages caused to the defendant by grant of injunction. The pecuniary award of damages is consequential to the adjudication of the dispute, and the result therein is incident to the determination of the case by the court. The court can do so in exercise of its inherent jurisdiction in doing ex debito, mitigating the damage suffered by the defendant by the act of the court in granting injunction, restraining the defendant from proceeding with the action complained of in the suit. Such a procedure is necessary as a check on abuse of the process of the court and adequately compensate the damages or injury suffered by the defendant by act of the court at the behest of the plaintiff. Over.